Good evening. This week we'll investigate legal issues as they affect e-commerce. Tonight we'll discuss online legal issues, contracts, intellectual property, online crime, terrorism, and warfare. We'll also discuss ethical issues, privacy, and taxes. The Apple App Store gives iPhone and iPad users an easy way to purchase applications, and it generates more than $10 billion in revenue for Apple each year. In 2013, Apple agreed to refund charges made due to their 15-minute purchase authorization clause. The FTC investigation resulted in Apple paying $32.5 million in claims, and they had to change their 15-minute purchase terms. In 2015, the FTC began another investigation against Apple for potential anti-competitive practices. The investigation is ongoing and could lead to a U.S. Justice Department investigation. The legal environment of electronic commerce. All businesses must comply with the same laws and regulations and face the same set of penalties. Web businesses face additional complicating factors. The web extends reach beyond traditional boundaries. A website is subject to more laws more quickly than brick-and-mortar businesses. There are more interactive and complex customer relationships online. And online communication facilitates strategic alliances and supply web relationships, as we've discussed. Law violations or ethical breaches can lead to rapid and intense reactions almost immediately. Borders and jurisdictions. In the physical world of traditional commerce, territorial borders clearly mark the range of culture and the reach of applicable laws. Geographic influences of culture decides acceptable ethical behavior and affects laws both directly and indirectly. Relationship between geographic and legal boundaries is defined by four variables: power, effects, legitimacy, and notice. Power and effects. Power is the form of control over physical space and over people and objects that reside in that space. It's the defining characteristic of statehood. Jurisdiction is the government's ability to exercise power. It's limited to that which is accepted by the geographical culture. The term effects are the results of a person's behavior, generally stronger on things that are physically closer. Laws based on traditional effects-based measures do not work as well for online businesses. Legitimacy is the idea that those subject to laws should have some role in formulating them. Notice is the communication of a change in rules. Constructive notice of new laws and norms is assumed when an international border is crossed. Ignorance of the law is not a sustainable defense. Creates problems for online businesses when unknown customers from other countries access websites. A jurisdiction on the internet is difficult due to the lack of geographic boundaries. Governments enforcing internet business laws must establish jurisdiction over conduct. A contract is a promise between two or more entities providing for an exchange of value between them. A breach of contract occurs if either party does not comply with the contract terms. A tort is an intentional negligent action taken by a legal entity that causes harm to another legal entity. Sufficient jurisdiction requires both subject matter jurisdiction and personal jurisdiction. Subject matter jurisdiction is a court's authority to decide a particular type of dispute. U.S. federal courts have subject matter jurisdiction over issues governed by federal laws. U.S. state courts have subject matter jurisdiction over issues governed by state laws. The rules here are clear and easy to apply, and there's few disputes on jurisdiction. Personal jurisdiction is determined by the residence of the parties. If the defendant is a state resident where the court is located, the determination is straightforward. An out-of-state person or corporation can voluntarily submit to a state's court's jurisdiction. Long-arm statutes create personal jurisdiction over non-residents committing tortious acts. Tortious acts are an exception to personal jurisdiction. A negligent tort is unintentionally selling a harmful product. An intentional tort is knowingly or recklessly causing injury to a buyer. Jurisdiction in international commerce is governed by treaties between countries that are involved in the disputed parties. The U.S. determines personal jurisdiction for foreigners in the same manner as domestic long-arm statutes. Non-U.S. entities can be sued in U.S. courts. Foreign courts can enforce U.S. court system decisions against U.S. corporations and individuals. Judicial comity is enforcing other countries' law out of a sense of friendly civility, or comity. Complex issue that is rapidly changing and should be considered when conducting business online is jurisdiction in international commerce. When business is governed by federal, state, and local laws, a conflict of laws occurs when laws address the same issues in different ways. Online businesses span many localities, states, and may usually look to federal laws for guidance. However, that can cause problems with state and local laws. And here we see a graphic on the relationship between culture, ethics, and laws. And the power, effects, legitimacy, and notice provisions are a mapping of physical geographic boundaries to legal boundaries. And again, power is the control over space, people, and objects. The effects of people's actions are stronger when they're closer. Legitimacy is the mandate of those people subject to the law having a right to form those laws. And notification is so that people know about the laws they have to comply with. And here we see a typical legal provision for forums, and you, of course, have seen other types of terms of use for other types of social media. So let's talk a little bit about contracts. A contract is formed when one party accepts the offer of another party. An offer is a commitment with certain terms made to another party. Acceptance is the expression of willingness to take an offer, including all the stated terms. Consideration is the agreed upon exchange of something valuable, such as money, property, or future services. An implied contract can be formed when parties act as if a contract exists, even if unwritten. One party cannot unilaterally change the terms. Every type of agreement or exchange between parties is a type of contract. It's a key element of traditional and internet business. Internet communication offers and acceptances occur by exchanging emails, engaging in EDI, and even in filling out web page forms. These can be combined with traditional methods of creating contracts. Courts tend to view offers and acceptance as actions that occur within a particular context. One of the types is end-user license agreements, or EULAs. The user must accept the contract before installing software, and that can happen when agree is clicked. Shrink wrap acceptance used to be used in the past with contract accepted by removing the plastic shrink wrap on the software box. Click wrap acceptance happens by clicking a button on the website. And web wrap acceptance, or browser wrap acceptance, occurs by simply using a website. Many sites have stated rules visitors must follow, even though the visitors may not be aware of them. These terms of service agreements are detailed rules and regulations, and they limit the website owner's liability for what one might do with website information. The site visitor is held to terms of service simply by using the site. Many contracts are valid even if not in writing or signed. The statute of frauds, which is typically handled by state laws, specify which contracts must be written and signed. Generally, sales of goods over $500 and contracts with actions that cannot be completed within a year are handled under the statute of frauds laws. For electronic commerce, writing exists if the contract terms are reduced to some tangible form, and the signature is any symbol executed or adopted for the purpose of authenticating a writing. An implied warranty is a promise to which the seller can be held even though the seller did not make an explicit statement of that purpose. Law establishes basic elements of a transaction in any contract to sell goods and services, and a warranty disclaimer is a statement declaring that the seller will not honor some or all implied warranties. Such disclaimers must be made conspicuously and in writing. The disclaimers are only legally effective if they're obvious and easy for a website buyer to find. Contracts are formed when the offer is accepted for some sort of consideration. Problems with acceptance by an imposter or someone without authority to bind the company occur. Electronic commerce technology provides means to avoid deception, such as the use of digital signatures. Authority to bind issues arise when an employee accepts a contract and the company later asserts the employee was not authorized to sign contracts for the company. And here we see the contracting process in an online sale. The seller invites offers, the buyer provides an offer, and then the seller accepts that offer. And here's an example of a website warranty disclaimer, in writing, of course. And as noted, sometimes the text for the disclaimer is capitalized for emphasis. Next, let's talk about intellectual property. Intellectual property includes all products of the human mind, both tangible and intangible. Protections are afforded by copyrights, patents, trademark registration, and service marks. Right of publicity is the limited right to control others' commercial use of an individual's name, image, likeness, or some identifying aspect of their identity. It's limited by the First Amendment provisions in the United States. Online businesses must avoid infringement of intellectual property rights by not using unauthorized content on websites or in domain names. A copyright is a right granted by the government to the author of a literary or artistic work. It gives the author, the creator, sole and exclusive right to the work, in other words, to print, publish, and sell it, for a specific length of time. Includes all forms, virtually all forms, of artistic or intellectual expression. The idea contained in an expression cannot be copyrighted. For example, mathematical calculations. Collections of facts can be copyrighted if the arrangement rises to the level of an original work. An example of that would be the Yahoo web directory. U.S. law no longer requires copyright registration. Works created after 1989 are copyrighted automatically by virtue of the copyright law. Most U.S. web pages are protected by this automatic copyright provision. Copying a page is generally an allowable use. There's a fair use of a copyrighted work that's an exception or exemption from infringement. It allows copying a work for use in criticism, comment, news reporting, teaching, scholarship, or research. There's some specific factors in fair use. Nonprofit educational uses have better chances of qualifying than commercial uses. Small sections qualify when an entire work might not, and the court might consider the amount of damage caused to the value of the copyrighted work. There are some good website sources, as mentioned in the book, to determine fair use. The University of Texas Copyright Crash Course and the Stanford Copyright and Fair Use. Copyright law is difficult to apply due to elements such as fair use, and the internet has made the situation worse. Vicarious copyright infringement occurs when an entity who is capable of supervising an infringing activity obtains a financial benefit from that infringement. For example, Napster was held liable for failing to monitor its network and indirectly profit from the infringement of music copyrights. Music purchased in digital form is often sold with specific restrictions on copying and sharing, even for personal use. A patent is an exclusive right granted by the government to an individual to make, use, and sell an invention. An inventor can patent a design for 14 years. The invention must be genuine, novel, and useful. And that's not obvious anymore given the current technology state. Software patents are not considered useful because technology obsolescence happens before the patent protection can be secured. The patent process is expensive and takes several years. Business process patents protect a specific set of procedures for conducting a particular business activity. Enforcing those rights is not clear, and several cases illustrate this: Amazon versus Barnes & Noble and Merck Exchange versus eBay. Patent assertion entities, or patent trolls, purchase patents they believe are being infringed. They then threaten to sue the infringers and get a cash settlement. Several governments have introduced legislation to limit patent trolls, but these legislative attempts have had limited success. A trademark is a distinctive mark, device, motto, or implement that a company affixes to goods it produces for identification purposes. A service mark identifies the services provided. They're registered with governments, state or federal, or both. Trade name is the name the business uses for identifying itself. It's protected under common law, but not under trademark law. Statutory law arises when elected legislative bodies pass laws or statutes. The website designers must not use any trademark name, logo, or other mark without permission. Cyber squatting is registering a trademarked domain name, hoping the owner will pay money to acquire the URL. This is prevented by the United States Anti-Cyber-Squatting Consumer Protection Act that was passed in 1999. Several disputes are settled by have been settled by the World Intellectual Property Organization, but critics claim enforcement hasn't been consistent. Rules in favor of the trademark owner happen 90% of the time. No central authority for appealing these rulings either. Name changing or typo squatting occurs when someone purposely registers misspelled variations of well-known domain names. Name stealing is unauthorized changes to domain name ownership. Domain name ownership change occurs when information maintained by a public domain registrar is changed in the registrar's database. This allows the name stealer to manipulate the site. It occurs when safeguards are not in place and the main purpose is to harass the site owner. A digital watermark is a digital code or stream embedded undetectably in a digital image or audio file. It can be encrypted to protect its contents. One example of a service is Digimarc. Copyright control is an electronic mechanism limiting the number of copies. And here we see fair use exemptions or exceptions to the copyright law. So it's important to be honest with your e-commerce site and to avoid defamation, deceptive trade practices, and to be fair in your advertising. A defamatory statement is false, and it injures the reputation of another purpose or company. Product disparagement, when the statement injures a product or a service reputation, can happen on websites. So these sites must consider the specific laws before making negative, evaluative statements about products. Website designers must avoid potential defamation liability by not altering photos or images of these products or persons. Exceptions in the U.S. for defamatory statements are about public figures. So these defamatory statements are not generally enforceable for public figures in the U.S. However, they are in other countries. Per se defamation occurs when statements are so negative that injury is assumed. Manipulation of trademarked objects constitutes infringement or of the trademark holder's rights. This is an example of a deceptive trade practice. Fictional characters can be trademarked. Websites with links to other sites must not imply a relationship with that company's site unless it actually exists. Trademark protection prevents buyer confusion regarding the trademark holder's products or services. Trademark dilution is the reduction of the distinctive trademark quality by alternative uses. The Federal Trade Commission, the FTC, regulates advertising. It publishes regulations and investigates false advertising claims in the United States. Websites that do include links to advertising regulations. Advertising claims that mislead a substantial number of consumers in a material way are illegal in the United States. The FTC accepts referred investigations from organizations like the Better Business Bureau. The FTC policies include information on what is permitted in advertising. Policy statements cover specific areas: bait advertising, consumer lending and leasing, endorsements and testimonials, energy consumption statements for home appliances, guarantees and warranties, and prices. Other agencies also regulate online advertising: the Food and Drug Administration, the Bureau of Alcohol, Tobacco, and Firearms, and the Department of Transportation. Let's now go into some aspects of online crime. Web crimes are online versions of physical world crimes, and there's also new online crimes: theft, stalking, pornography distribution, and gambling. Commandeering a computer to attack other computers would be examples of web crimes. Law enforcement jurisdiction has several obstacles for web crimes. Prosecuting across international boundaries is difficult. online gambling, uh, Unlawful Internet Gambling Enforcement Act of 2006 did provide clearer jurisdiction, though, for this issue. Some of the new types of crime online, difficult to interpret the pre-internet laws to criminal actions on the internet. Most stalker laws are triggered by physical action, which are not effective against online stalkers. Cyberbullying is using technology to harass, humiliate, threaten, or embarrass another person. Laws have lagged behind technology, but most states are starting to pass laws that address some of these new online offenses, stalking, and cyberbullying. Sexting is sending explicitly sexual messages or photos using a mobile phone. It can lead to a serious criminal liability if minors are involved. Infiltrating competitor computer systems with the intent of stealing data or creating operational disruptions is another new form of online crime. This often results in criminal extortion, and an example is Myron Tereshuk was convicted for threatening micro-patent with confidential client information disclosure. The National Retail Federation partnered with eBay and the FBI to combat stolen items from being sold online. The internet can help law enforcement track criminals. Some brag on social networking sites or leave clues in online profiles. The new age of terrorism and warfare is now using the internet. A considerable number of websites are operated by hate groups and terrorist organizations. They have instructions for creating biological weapons. They help terrorist groups recruit new members online. And thousands of downloadable terrorist training films are available. The U.S. Department of Homeland Security and Interpol are devoting considerable resources to monitoring online terrorist activities and coordinating anti-terrorism efforts. A sustained terrorist effort could slow down major transaction processing center processing. Websites conducting electronic commerce should adhere to the same ethical standards other businesses follow. The failure to do so will result in a damaged reputation, long-term loss of trust, and loss of business. Web advertising or promotion should include only true statements and omit misleading information. Product comparisons should be supported by verifiable information. An ethical lapse reported and passed among customers can seriously affect a company's reputation. One example is Amazon.com arrangements with publishers for book promotions, eBay sales, and Apple App Store software, and its approval time is another example. Organizations face an ethical issue when collecting email addresses from site visitors. In the U.S., there's no legal obligation to limit the use of information collected on websites. So they may use this information for any purpose, including sales. Concerns of individual and privacy right advocates are being raised because of this. There's an issue of online privacy that's continuing to evolve. Many legal and privacy issues are unsettled and remain hotly debated in various forums. The Electronic Communications Privacy Act of 1986 is the main law governing privacy on the Internet today. It was written pre-Internet to deal with telephone lines. No law has been enacted to address online privacy that has survived the constitutional challenge. A 1999 FTC report concluded that no federal laws regarding privacy were needed. This created outrage among the various privacy advocacy groups. The Direct Marketing Association, DMA, established a set of privacy standards for its members. It lobbies on behalf of members who do not want privacy laws that would impact business. There's significant ethical issues in online privacy. The laws are not keeping pace with the internet and web growth. The nature and the degree of personal information recorded threatens visitor privacy rights. And there's many examples of personal information that's been lost or stolen. Security breaches are continuing to increase. Worldwide, the cultural differences provide different electronic commerce privacy expectations. Most European countries prohibit companies from exchanging data about people without their express consent. A major controversy in the United States is opt-in versus the opt-out issue. Opt-out is the common method where the customer must deny permission or opt out of having their information used. Opt-in is the less common method where the customer must explicitly give permission to have the information used. Privacy advocates urge electronic commerce websites to be conservative and follow these guidelines. Use the data collected for improved customer service or other customer benefits. Do not provide customer data to others outside your company without the customer's permission. Clearly describe and explain what data is collected and how it is used. Give customers the right to have their data deleted, and train employees how to keep the data secure. Additional privacy considerations arise when websites attract and communicate with children. Children are considered less capable of evaluating information sharing and the risks in these transactions. The concern arises about their ability to read and evaluate privacy statements and consent to providing personal information. In most countries, people under the ages of 18 or 21 are not considered adults. Specific laws for children's privacy rights define a child as a person below the age of 12 or 13. In 1998, the Children's Online Protection Act was passed. The Children's Online Protection Act of 1998 was at first considered unconstitutional. It was revised, and it is now considered constitutional, but it does not regulate content as thoroughly as the original act would have provided. In 2001, the Children's Internet Protection Act was passed, and it provides federal funding to schools to install filtering software. Companies with websites appealing to children must be careful to comply with laws governing the interactions. Disney is an example of this. In 2013, the Federal Trade Commission provided some rules clarifications. Sites must post clear and comprehensive online privacy policies. They must give notice to parents and have verifiable parental consent. Give parents the choice of allowing data collection without disclosure to third parties. Provide parents access to their child's information and have the option to delete it. And give parents the opportunity to prevent further data collection and to take steps to maintain the information's confidentiality, security, and integrity. So here we see an example of web page opt-in choices. Here we see an example of web page opt-out choices. And here we see Scenario, which is like Disney, a company that has a lot of children visiting the site. Here's their approach to the Child Online Protection Act compliance. Let's finish up with taxation. Web businesses must comply with multiple tax laws. There are several types of taxes. Income taxes are levied on net income. Transaction taxes are levied on products or services a company sells or uses, and these include sales taxes, use taxes, and excise taxes. Property taxes are levied on personal property or real estate. There's a connection between a tax-paying entity and the government. And this is similar to the personal jurisdiction that we discussed earlier for legal application. Activities creating this tax-paying nexus are determined by state law that vary from state to state. Frequent litigation has resulted in fairly complex laws. Determining nexus is difficult if the company conducts few activities in the state. Business conducted in more than one country may establish a nexus with one country and be liable for filing returns in that country. So you have to be careful with the web because you're going to be potentially dealing with customers from several different countries. The Internal Revenue Service, the IRS, is charged with administering U.S. income tax laws. Any verifiable increase in the company's wealth is subject to federal taxation. A company must pay federal income tax if it has a U.S.-based website generating income. Website maintained by a U.S. company must pay taxes on income generated outside the United States. You are given a credit for taxes paid to foreign countries to reduce double taxation of foreign earnings. Most companies also levy income taxes on businesses. U.S. state sales taxes. A transaction cost on goods sold to consumers is usually called a sales tax. Businesses establishing a nexus within a state must file sales tax returns and remit sales tax collected from customers. Businesses not required to collect taxes from out-of-state customers is the default unless a nexus has been established. Use tax is a tax levied by a state on property used in that state that was not purchased in that state. Large companies use complex software to manage their sales tax obligations. Purchasers exempt from sales tax include charitable organizations and businesses buying resale items. Amazon laws require online retailers to collect taxes on sales made in their state. The Supreme Court refused to hear a case challenging these laws, which are being considered in many different states. The streamlined sales and use tax agreement would simplify state sales taxes. Countries regulate import and export of goods, and sometimes goods can only be imported if a tariff is paid. A tariff is a tax levied on products as they enter the country. There's many reasons for imposing tariffs. Goods ordered online are subject to tariffs when crossing international borders, and products delivered online are also subject to tariffs. For example, downloaded software. And then there's also the European Union value-added taxes. The European Union uses transaction taxes, with value-added tax being the most common. The value-added tax was adjudicated to apply to the sales of digital goods in 2003. Okay, that concludes the lecture for tonight, and we'll see you on the forums.